Everybody. Thank you. We might kick off and welcome you all to our very first PowerPrint for 2024, the P.o.P, Share the Knowledge. We're still learning the acronym. Today we've got some 50 people registered, some registering for the recorded link, which you will all receive following this. So for those who are listening live, welcome. And you'll also receive tomorrow the class notes, which is a summary to this session, as well as the recording link. You get to listen to my dulcet welcoming tones again tomorrow. But it's also something you can share with your colleagues and your network. So please do. This is our fourth Power of Print or P.o.P webinar series summit. We started it as Rebuild Together in COVID, and it was so successful that we then ran the Power of Print Summit, which we brought across from the UK. The UK, our friends over there, run a similar event every year. And then last year, we mimicked them even further from the webinar series. We had a live event. However, you are the masters of all, and the feedback was that you wanted to maintain the webinar series. So that's what we've returned to this year, and I love the format because I love going back and forth and listening to the lineup of experts that we have and we'll bring to you across the next 8 weeks. There are two major reasons that we can be here today, and that is because of our partner sponsors. RICO, we have announced this in previous years, and we continue to announce their ongoing support. They are a true partner of the industry. They provide us the sponsorship and support to bring these sorts of activities and programs to you. They see investment in the industry as investment in their future as much as it is for everyone. It's not an exclusive arrangement, so any suppliers listening, we welcome more partnerships because supporting an awards is fabulous, but we really want to support industry programs like this. And I thank the RICO team. They're terrific to work with, and their support has been continued this year, which is brilliant. Our ongoing and long-standing industry partner is also Media Super and our industry super fund. We don't have any other industry super fund. We have Media Super, like the Visual Media Association, dedicated to representing and working for our industry. Again, I've had the privilege of working with the Media Super team now for over a decade, and they continue their support of these sorts of programs and making sure that they're investing in our future and our knowledge as well. The housekeeping is pretty simple with this. You're all muted, and you can pop in some questions through the chat. You can pop in questions that you might have as Charles, our speaker I'll introduce in a moment, talks through today's session. I also get people texting me and things like that throughout the sessions. That's absolutely fine. Any way you want to ask a question, I'll facilitate that at the end. But during the actual presentation, you will be muted. This is a recorded webinar, and as I say, links will be sent tomorrow and posted live. So we just need you to be mindful of that for legal reasons. We've got a legal speaker, so we might as well keep all the legalities in check today also. At the end of the summit, so now that you've registered for one, you'll get access to each week, but at each week's webinar. And then at the end of the summit, we'll be sending out the class notes as a printed booklet for you all to then also refer back to if you wanted to watch the webinars again. This information over the next 8 weeks is information that you can use and cut up in all different ways across your businesses. So we encourage you to do that. Well, without further ado, though, you're not here to listen to me. You are here to hear from Mr. Charles Watson, our General Manager of Policy, IR Policy and Governance. I've had the privilege of working with Charles also for some 10 years. He has been working directly for our industry for some 13 years. I don't think there's anyone who knows more about HR, IR, legislation, policy, best practice, and with true expertise for our industry than Charles. I've had the privilege of actually working directly with Charles as part of the team for now. I think we're getting up to four and a bit years. I often say everyone needs a Charles in the universe, and I'm very privileged to have one. He's extremely knowledgeable. He's also extremely considered, which gives us a great insurance card, all of our members, a great insurance card across some matters that can be difficult to navigate, legislation and law, particularly in this current landscape. There's a lot of different changes going through with IR reform and legislative reforms. Understanding the detail and being in Charles's very safe hands is something I feel very confident in delivering for our members. But more importantly, I have countless numbers of emails that come in from members congratulating Charles, thanking Charles, and endorsing all of the sentiments that I've just mentioned to you. He has a Bachelor of Laws, postgraduate studies in Industrial Relations Law, and is a Fellow of the Governance Institute of Australia. He's worked for some of the most preeminent legal firms across the country and has some 20 years' experience on top, inclusive of the 13 specific to our sector. Today, I'm going to hand over to Charles. He's going to talk about the sort of top 5. We're talking about what were members coming to Charles about across HR/IR matters. He's going to talk today about the top 5 common issues that he's currently being inquired about. But most importantly, with these changes and different legislative amendments going through, he's going to talk about how we can manage those in our businesses and what are the important things that we need to do. I'll hand over to Mr. Watson. Thank you.
Thanks, Kelly. Geez, nice introduction. Thank you. Putting the pressure on, but if everyone's sitting comfortably, let's begin. Essentially, what I've learned from the past 20 years from working in the workplace relations space, it could fill a textbook, and it's a textbook maybe one day I'll write, although it's probably not going to hit the Dimick's bestseller list. However, in an attempt to summarise the most obvious lessons, perhaps the obvious lessons and understandings I've come to in this pretty enormous field, is that successful businesses need high-functioning and productive employees. Workforces, your workforce, and workforce-related costs account for approximately 70% of your business operating costs. Australian businesses are covered by highly regulated and complex employment laws. Employment laws or employment law and practices are never static. They change with each new government, and sometimes, as we've seen, several times within a particular government's term. And that workplace relations, as a broad term, encompasses a significant number of subheadings, if you will, under that term. So as a result, businesses need to regularly, if not constantly, be looking at their HR, their people and workplace relations practices to stay on top of them for both compliance as well as for best practice. And the particular issues I'm going to cover today could each have their own webinar or seminar, and we'd still only be scratching the surface. But that's okay, because you've got the Visual Media Association to help you when you've got a related question. It's what I do, but it's only part of what you do in running a great and successful business. Nevertheless, having an understanding of, well, what is the 5 current commonly queried issues, and specifically certain related elements of those issues, will assist you in your compliance and ensuring you have a cohesive and productive workforce. So in today's webinar, we're going to cover contracts of employment, some do's and some don'ts, certain elements of the Graphic Arts Printing and Publishing Award, the Common Industry Award. We'll have a look at workplace policies, what you need and why. We're going to look at a particular people management issue, which is, in this case, the respect at work, the recent legislative changes and amendments that have come into being. And then we're going to finish up on looking at exiting employees and where employers can make some mistakes and how to overcome those. Okay, so contracts of employment. I used a quote there from Samuel Goldwyn, a verbal contract is not worth the paper it's written on. You've probably all heard that before, but on this issue, I'd like to dive into why carefully and appropriately drafted contracts of employment are pivotal for the employment relationship and how they can help to mitigate risks. A well-drafted contract of employment is a legal document that outlines the terms and the conditions of employment between an employer and an employee. Beyond it being just a legal agreement, it acts as a clarifying guide for both parties. It sets clear expectations and responsibilities, and this clarity, it's essential for preventing misunderstandings and disputes that could arise from ambiguous or conflicting terms. So a properly and well-drafted contract of employment can protect your business interests. So the contract can include terms such as confidentiality and non-compete clauses to safeguard your proprietary information and prevent employees from engaging in activities that could harm your business. They can also outline terms in relation to termination, including notice periods and grounds for dismissal. Further, a well-drafted contract can also ensure that you're compliant with relevant laws and regulations. As I said earlier, the employment laws are constantly evolving and they are complex, and this makes it crucial that you have a contract that's up to date and compliant with those latest legal requirements. So some rules of thumb. Don't include unnecessary or inappropriate terms within a contract. For example, a post-employment restraint for an account manager is going to look quite different to that of a production employee. Conversely, you will want to have some form of post-employment restraint in your contract for an account manager, and those post-employment restraints typically include non-solicitation of clients and non-approaching of your clients, and for a period of maybe 6 or 12 months, as long as that post-employment restraint is fair and reasonable. It should therefore be enforceable if an ex-employee seeks to breach that term. As I said, their templates can work, but they have to be customised. I've seen in the past, I've seen businesses utilise a template, and unfortunately, they may have missed a term that might be specific or should be specific to that particular employee. If an award applies, such as the Clerks Award, the Commercial Travellers Award, or the Graphic Arts Printing and Publishing Award, that award should be referred to in the contract and make it very clear that the terms of that award do in fact apply to the employee. Clarifying the employment status. If an employee is part-time, state that they're part-time. If they're full-time or casual, state that. Again, that saves an employee later on saying, oh, but I thought I was something else. All contracts of employment should have a probationary period, and I always recommend using a 6-month probationary period. If a business determines that the new employee isn't working out, they can seek to rely on that probation period or that probationary term and the clause to exit them out of the business. However, if you have a contract with a probationary term and you let the employee go one day outside that probationary term, and you sought to rely on the fact that they were unsuccessful during a probationary period, you can't actually rely on it. Once they're outside the probationary term, you're going to have to look for another basis for the termination. Another one, detail salaries and superannuation. It's to good effect if a contract details how superannuation will be managed. That might include a term stating that if the employee doesn't nominate a particular fund, the employee is going to direct it to a default. Now, on the issue of workplace policies, I don't advocate employment contracts incorporate the terms of workplace policies holus bolus, if you will. Rather, they should be referred to generally in the contract, and that the employee is obviously required to adhere to those workplace policies, and as they may be amended periodically. Whereas if you have to put, or if you do put those terms directly into, or those policy terms directly into a contract, technically you're going to have to renegotiate those workplace policies as part of renegotiating a contractual term. So refer to them, don't put them in there. Another one, don't include a contractual term saying there's going to be an annual performance and pay review unless you intend to comply with that term. Technically, it could be seen as a breach of the contract by not undertaking such a review. That might best fall into a workplace practice or policy. Similar to workplace policies, refer to in the contract a well-drafted position description that sets out people's key duties and responsibilities. By keeping that job description separate means that it's going to change over time naturally, of course, but the contract may not need to be redrafted. Some additional considerations arising out of the recent tranches of the amendments to the Fair Work Act. One of those is that the Fair Work Act now prohibits the inclusion of any pay secrecy clauses in employment contracts. Pay secrecy clauses prohibit employees from disclosing their remuneration and conditions of employment. Those are now prohibited under the Fair Work Act. Another recent change is that under the Act, the limitations on the use of fixed-term employment contracts, particularly where the fixed-term contract is longer than 2 years, or that a renewal of that contract will increase the term to be longer than a 2-year period. Another point, there are Fair Work information statements produced by the Fair Work Ombudsman that must be provided to all new employees, whether they're the CEO or a casual table hand. They must be provided, and I still see businesses forgetting to provide those to their employees upon or prior to commencement. And just to finish on contracts of employment, get the contract signed by the employee. Although an employee may have been operating under the terms of a contract, they'll be the first to say, "Oh, but I didn't sign that," if an issue arises later on, and they'll take the view that certain employment terms didn't apply to them. Nip that in the bud by having them sign off on their contract prior to commencement of employment. So that leads us to the related issues of workplace policies. So workplace policies, they communicate an organisation's values and expectations to employees and external parties. The purpose of a workplace policy is to set the minimum standards relating to a particular issue. These could be obvious policies such as conduct, sexual harassment, bullying, discrimination, those sorts of policies and procedures. They may include the legally necessary, such as a work health and safety policy, as well as other beneficial policies to the workplace or for the workplace and for employees that may cover issues such as use of social media, leave policies, and even dress codes can be a necessity and are still permissible. Businesses can't just have workplace policies and think that because they brought them in some years ago that they're compliant, or that reliance on a workplace policy will naturally perhaps create a great workplace culture. It's more complex than that. The business's board or the C-suite or senior management, company leaders, you all have the responsibility to walk the talk every day to ensure that your workforce observes what is expected of them by having clear and well drafted and updated policies, and that those policies are reiterated on a regular basis. Your workforce is going to be happier, healthier, more cohesive, and more productive. Another point I'd make on workplace policies, when you're drafting them or when you're looking to review them or to create one to implement, don't forget to engage or get input from your workforce when reviewing or developing those workplace policies. It means they've been part of the process in the design and the consultative way. And as a business owner, you mightn't agree with their input, but at least you did have a consultative approach to your workplace policies. Another issue: if you have a particular workplace policy in the workplace and you do need to apply it consistently, whereas inconsistent application of policies can be a negative. If the company seeks to utilise that policy against a particular employee or in a particular situation when it hasn't been applied to another employee in the same situation. Okay, the Graphic Arts Printing and Publishing Award. So although employees in our industry apply various awards to different employees within their business, such as the Clerks Award, the Commercial Travellers Award, the primary industry award is the Graphic Arts Printing and Publishing Award 2020. Given the limited time we've got today, I'm just going to touch on a few interesting issues that arise regularly or are not abundantly clear or that well known. The first one, interestingly, is clause 16, which refers to a refreshment entitlement. This is separate to the Graphic Arts Award meal break entitlement in clause 15. And if you don't have a predetermined rest break or a morning tea break in the workplace, employees are entitled to a reasonable opportunity to pause to acquire a refreshment during the first half of the day or their shift, and at a time specified by the employer. Practically, this break should allow your employees to grab a caffeinated beverage of choice drink it and get back to work. Such a refreshment break's not to be used in a way that would affect continuous running of production, or that would otherwise affect work health and safety in the workplace. And it's something that a number of workplaces just stagger as and when it's possible. Again, it shouldn't be used to reduce any other meal break or rest entitlement that your employees may otherwise have. Clause 24, work organisation. I get calls on a semi-regular basis to discuss a scenario, a common scenario, where an employee doesn't want to perform particular duties, such as moving from one particular type of machine to another or similar. Although they may have a reason for such a reaction, sort of obstinance and refusal by the employee is generally not acceptable. I'll sort of read from clause 24. An employer may direct an employee to carry out duties that are within the limits of the employee's skill, competence and training, provided that the duties are not designed to promote de-skilling. Any direction issued by the employer must be consistent with the employer's responsibility to provide a safe and healthy work environment. So if you've got an employee and there's some duties within their skill set, you do have a right to direct them to perform those duties, and such a direction would generally be fair, lawful and reasonable. Of course, you need to do it carefully and consultatively, but you can refer to clause 24 of the Graphic Arts Award if you need to. On the issue of redundancy, another scenario that crops up is when an employee's position is no longer required and becomes redundant, and they're working out a notice period. But that employee may determine to cease work earlier than the conclusion of the notice period, perhaps as a result of lining up a new job. Pursuant to clause 42 of the Graphic Arts Award, if during that notice period that they're working out, the employee is entitled to terminate their own employment during that period so as to finish up earlier. And if they do that, they continue to be entitled to receive the redundancy related benefits. So that's, in old terms, the severance component. They would have received should they have remained for the entire notice period. However, under those circumstances, and by leaving earlier than the conclusion of the notice period, they're not entitled to receive the remainder of the notice period. And obviously the calculations for their accrued leave, for instance, should be as at the close of business of the day they cease work. Finally, on issues to do with the Graphic Arts Award, long service leave. Successive federal governments have not got around to nationalising long service leave. I've been around long enough that the Howard government's legislative changes and then the Rudd-Gillard-Rudd government's legislative changes, and ever since then, no government's actually got round to sorting out nationalising of long service leave. So for a number of employers who don't have or haven't been around for that long, although they don't form part or a term of the modern Graphic Arts Award, or even referenced in the Graphic Arts Award, the long service leave entitlements and related provisions that were terms under the pre-modern award, the old Graphic Arts General Award 2000, they continue to apply under specific circumstances. essentially, if you've got a production-related employee who is employed in a metropolitan printing business and under the terms of the Graphic Arts Printing and Publishing Award, they will most likely have the terms of the long service leave within that pre-modern 2000 award apply. Unless, of course, their employer applied something that was more generous and more advantageous to the employee. So those long service leave provisions from the pre-modern award continue to apply pursuant to the Fair Work Act. That's with entitlement to 13 weeks leave after 15 years of continuous service and 8 2/3 weeks after or for each 10 years service thereafter, or if after 10 years of service there's a proportionate entitlement that is payable on termination, for resignation or reasons of redundancy, but not termination for reasons of misconduct, based on that 13 weeks for 15 years service. If your business is outside that metropolitan state capital or certain specified locations in the old award, then your state's long service leave provisions will continue to apply. Okay, respect at work. I'm sure everyone's aware that sexual harassment in all its forms, and particularly sexual harassment in the workplace, is unacceptable, and it's been unlawful for some considerable time, and it's under both the Sex Discrimination Act, workplace health and safety legislation, and even criminal law. At its core, sexual harassment is unwelcome conduct of a sexual or sex-based nature in relation to a person. It occurs in circumstances where a reasonable person would anticipate the possibility of that person who is harassed, in that they would be offended, would be humiliated, or potentially would be intimidated. With the enactment of these recent Respect at Work laws, there is a broader scope of included issues. And there's also greater powers handed to the Fair Work Commission and the Human Rights Commission. Previously, the Human Rights Commission could hear a matter that was raised with it formally, whereas the Human Rights Commission now has investigative powers, so that if a complaint's made about an employer, the Human Rights Commission can directly investigate that at the workplace. Probably the most relevant issue to come out of this recent tranche is also the positive duty on employers, which requires proactive steps to be taken to eliminate unlawful sexual harassment, and as far as possible. So this new duty requires that all employers take all reasonable and proportionate measures to eliminate discrimination on the grounds of sex in a work context, sexual harassment in connection with work, sex-based harassment, or rather conduct creating a workplace environment that is hostile on the grounds of sex, and any related act of victimisation. This new positive duty, requiring sort of a proactive approach, it not only applies to employers but also to employees. So as far as how you discharge those obligations, as I say there on the slide, there's no one-size-fits-all approach, and it does depend upon the size of your business. But to kick it off, you're obviously going to be taking a zero tolerance approach on the issue. It does require sort of strong leadership and organisational commitment. You should be looking at identifying, controlling, and eliminating any potential risk. It is on the employer to develop a safe and respectful and inclusive workplace culture, and one that holds all employees to account for their actions. It may also require some level of education and ensuring that all management and employees are aware of these amendments and related obligations. As far as some practical steps that you could undertake, again, this is based on the size of your business, and some of those may include, if you're a smaller business, ensure your sex discrimination policies updated and compliant, and that you have a complaints handling procedure, and that it's provided to all your staff. It may be that you diarise a periodic check-in with staff to discuss the issue and to make it quite clear that if someone has a problem, that they're more than entitled to, and it's safe for them to raise that issue. If you're a slightly larger business, you may want to implement some management training on the issue. You may want to release a leadership statement and undertake regular reviews. And for a larger business, or if any business wants to undertake additional steps, you may want to undertake some confidential staff surveying, and on a de-identified basis, of course, and collect that data and see how it shapes where you think your business culture or your workplace culture is at, and whether you need to do anything to change. Now, if you require any assistance on this particular issue, we previously, late last year, undertaken or provided a webinar on the subject, and have a number of tools and resources that are available to assist you. So just log on to the website, and it's all there for you. Okay, looking at the time, right, hurry along. Okay, exiting employees. Everyone can have a bad day. However, ongoing poor employee attitude or poor performance isn't acceptable, and you as an employer have every right to manage that issue. I regularly see great employers tolerating what really is unacceptable behaviour, and for far too long. The best time to address that behaviour or performance or conduct issue is as soon as possible. Obviously, if there's no improvement after appropriate warnings and performance management, or the misconduct is so serious that it's inconsistent with an ongoing employment relationship, it's time to exit the employee. And no matter how frustrating that employee may be during that process, you nevertheless need to apply a fair process to the matter. Whereas if the reason for termination is for redundancy, because the employee's role is no longer required, before you get to the actual termination, you need to ensure that you've undertaken any and all consultation requirements contained in the Graphic Arts Award or another relevant award, their contract of employment, or if you have a company policy on the issue. Usually I find that the reasons for the termination for redundancy the reason is usually sound, but it's the consultation process that may have been improved so as to sort of limit any exposure the company might have at a later time for an employee to claim that, oh, it wasn't a genuine redundancy. I'd also highlight that wherever possible, the termination letter, even if you've drafted it already, it needs to sit in the drawer. A termination letter should really only be the confirmation of the meeting wherein the employee was terminated. So I generally recommend that that letter be sent to the employee in the post and after their departure. Now, no matter how careful and considerate as an employer you've been in reasoning and process, a disgruntled ex-employee can nevertheless take an action against you, their employer. Doesn't mean they're going to get up on it, doesn't mean they're going to be successful, but they often try nonetheless. Therefore, and I guess it helps me, document everything that happens in meetings, the considerations of the company, who said what, responses to questions, and this essentially creates evidence that can be used later if we need to defend the decision that you made and defend it in the Fair Work Commission.
Thank you. Thank you, Charles. There I am back on screen. I was madly typing away, madly doing notes. I've got a few questions flying in on the chat. Couple around long service leave. So there's a few queries around the out-of-date EA was cancelled. People transferred to the GAPA, Graphic Arts Award. Is this when transferred? Long service leave was taken from the pre-modern award, and the long service leave not accessible until 15 years. Previously, it was available from 10 years as per the state legislation. Contract state award or NES, whichever is more beneficial. Employees who have been with us over 10 years no longer have visibility of their long service leave and have questioned why it has changed to 15 years. Does the NES apply to these employees? And I'm just checking here on this other question, which is, I'll tie them all because they're both long service. Where does it lie if a person has a cross-state role? And I'll hand all of that over to you. There's a few acronyms in there I'm hoping you know about.
Right, okay, that's actually a really big question with a few possible outcomes. Taking or assuming that the business is in a metropolitan area of a particular state and that the old terms of the Graphic Arts General Award applied, and if you refer to the National Employment Standards, the NES, it talks about long service leave, and what it does say is whatever applied prior to the commencement of the 2009 Fair Work Act continues to apply unless and until the government nationalises or comes up with a national approach to long service leave. So whoever had that question, it's probably better I discuss that with them individually, but it should be that the old Appendix E of the old 2000 award, the long service leave provisions, continue to apply. Why that was changed with an enterprise agreement, I'm not 100% sure, and I'd need to have visibility of the enterprise agreement and what happened there. But if they had it cancelled, there's every chance they went back to the Graphic Arts Award, and as a result, what would have applied to those employees should they have been employed prior to 2009, and that would have been the old Appendix E Graphic Arts General Award long service leave provisions. It's a really interesting question there as well on if someone has a cross-border functional role. Generally speaking, it will be, what will apply will be where the employee is based. So if they're based in, oh, quick example, let's take Victoria in South Australia. So if someone is living and working in South Australia, but crosses the border into Victoria to perform work, it's likely that the South Australian Long Service Leave Act and the related provisions will apply. Again, it gets down to the minutiae with this sort of thing. So as you know, if the person who's asked that question wants me to cover it with them, yeah, just tell them to give me a call.
Okay, thank you. I think, Debbie, if you've got an answer to that, but please feel free to call Charles. Sounds like you may have something a bit more specific that he can go into the details with you on. And it's just interesting, this long service. It would be nice to sort of federalise it a little bit to make it a bit easier, particularly for those with multi-state sites. The next one is about respect at work. And this question actually reminds me a little bit of training that I've had some years ago when there was some criminal legislation introduced across bullying and harassment in the workplace. But I think it's important to provide the clarity. The question is, what happens if a manager knows but doesn't tell me? Where's the liability for the owner, employer in that instance? Could you just step that out? Because particularly, I'm in Victoria, there is some criminal, and I know in other states, responsibilities as well. And respect at work with positive duty, I believe, is a good step to, really implementing that you wouldn't not know, trying to make sure there's multiple communication channels and so
on. Okay, so assuming that the scenario is that the manager knows these amendments and changes to the laws, it's on them to, take into account company policies, perhaps leadership statements that have been produced and disseminated to employees. The manager knowing that these positive duties and requirements and changes are in place, it gets back to the old, if you see something, say something. If they aren't able to or feel confident enough in their knowledge to deal with an issue that they're seeing or experiencing, or that they're seeing an employee experience, get on the phone to me, or speak to someone else in the business. But like I said, with workplace policies, you can't walk past this anymore. If you're seeing something going on that is disturbing or concerning, it needs to be jumped on. And not only does it need to be jumped on for the workplace and for those people experiencing perhaps harassment or victimisation, but it has to be jumped on for compliance, because if that victimised employee goes to the Fair Work Commission and says this is happening, and they knew about it, and they did nothing, that could sort of be a bit of a reputational cause a bit of reputational damage. And if the Human Rights Commission, who having been given these new powers, are probably going to be a bit hungry to try and find a company who they can give a pretty big smack to, you need to be able to say, well, we did know and we did do something about it, and we did seek advice, and we have done everything we could possibly do or reasonably have done under the circumstances.
Yep, I think the positive duty is really important for everyone to understand, and the training includes your managers, not just a one-size-fits-all. The Visual Media Association has developed for members a lot of communication around this, a lot of posters you can put up, a lot of things that you can include in your toolbox meetings. So if there's some specific concerns on how you communicate the respect at work and the positive duty changes, speak with Charles, but also as a member, go into the member lounge, download that content and get it up around. You should be having posters everywhere, you should be having toolboxes, you should be really communicating this to all employees, including managers. It's, as Charles says, it's not something you can just walk past anymore. And there are liability linkages to owners as well as managers and so on. So positive duty means a very active step in addressing this across your businesses. And as Charles talks to about workplace policies. I've got another question for you, Charles. They're coming in thick and fast. We could do this all day. Are there any policies with regard to employees requesting transition to retirement, change from working full-time to part-time?
There's no policies per se, and I'll put a lawyer hat on and say for that issue, I might not necessarily recommend having a policy per se, other than to state that if an employee seeks to transition to retirement or wants to sort of discuss those things, that should be done on a case-by-case basis. Whereas if you do have a policy on that in the workplace, you're going to have to adhere to it, and depending upon how it's drafted, it may not be it may not sit comfortably with the business under the specific circumstances. But it's certainly something that an employee and an employer should be able to discuss.
And then, once that discussion, you can still do your modified agreements and things like that to provide your documentation. So if you don't have the policy per se to sort of manage that, you can sort of do the other stuff as well, right?
Yes, absolutely.
Okay, I'm running out of time, so I have to wrap up, Charles. To all of the members on the call, if there are some specific things, sort of matters that, from this you want to talk about in the more confidential environment with Charles, please contact Charles. He's available to you, charles@visualmediaassociation.org.au. For all any non-members on this webinar, Charles is included in your membership, and what a resource and insurance card to have in the back pocket for your business. So we always welcome new members, but certainly Charles is available to all current members and is certainly part of the membership for all incoming prospect members. Thank you, Charles, for today, as always. And I said it in my intro and I say it all the time, everyone needs a Charles in their lives, so every non-member can embrace that concept, and we're in good, safe hands. I will wrap up again thanking our two partner sponsors, Rico and Media Super. We wouldn't be able to bring this for you without their support. I also want to thank London, who's been coordinating all the speakers with the team and bringing this together for us, and is getting all the speakers, all the presentations, all the class notes. It's a lot that goes on behind the scenes on, you see us sort of turn up and have all the information. It's because I've got a really good team behind me, and London's been leading that, so thank you. Our next week's webinar is no stranger to our industry either, Mr. Steve Gamble. I've introduced him in the past as being one of the great humans that we have in our industry. He's an absolutely ripper of a human, and he's going to be talking about mental well-being across our workplaces, moving from compliance sort of matters to things that are really practical that we can implement in our businesses to develop culture and so on. So please tune in for that. As I say, as you've registered, you'll receive the link, the recording and the class notes as well. But certainly happy to, the more people that join us each week, the better conversations, the better Q&A that we have. So thank you for those who joined us live today. I really do appreciate the questions. There's a good few in there that helps everyone else sort of start dissecting the information. Thank you again to Charles, the team. Have a great day, and I look forward to speaking with you all next week. Thanks, everyone.